Good morning, sir. Can you see and hear me?
Yes, I can, thank you. Before we start today's proceedings, there's just something I'd like to mention to Mr. Henry and Mr. Maloney. Can you both see me?
Yes, sir, they can.
Fine. Well,
Oh, sorry, Mr. Henry isn't here, sir. Sorry, that was my fault.
Mr. Maloney is present, but not Mr. Henry. But I take it Miss Page is here.
Yes, sir.
Well, what I'd like to say is this, that I have reflected overnight on the decision which I made yesterday afternoon to close the proceedings without giving both Mr. Henry and Mr. Maloney the opportunity to put questions to Mr. Davis. I have decided that that was wrong of me, and accordingly I apologize to both Mr. Maloney and Mr. Henry, their professional and lay clients. All right, Mr. Stevens, we can continue.
Thank you, sir. So we have Mr. Bourke today. I'll just check that he can see and hear us.
I can, thank you.
Thank you. If I can call him, sir.
Good morning.
Yes, of course.
Good morning, Mr. Bourke. I'm the usher today. I'll be taking you through the oath. Can you hear me?
I can, yes, thank you.
Good. Do you have a Bible with you?
I do.
Could you hold it up, please, in your right hand? Thank you. And repeat after me. I swear by Almighty God.
Swear by Almighty God.
That the evidence I shall give.
The evidence I shall give.
Shall be the truth.
The truth.
The whole truth.
Truth.
And nothing but the truth.
Nothing but the truth.
Thank you very much.
So I should say we are due to have a fire alarm at 10 o'clock. I will simply pause while that goes on, and rather than have a formal adjournment.
Mr. Stevens, when Mr. Bourke was taking the oath, I found what he was saying quite difficult to hear. Was that your experience as well?
Yes, I was just about to try to. I agree. I think if we can ask Mr. Bourke. Mr. Bourke, can I ask you first just to state your full name?
It's Patrick Francis Ulick Bourke.
That's fine.
Thank you, sir. Thank you for giving evidence to the inquiry today. Mr. Bourke, you've provided two witness statements, which I want to go to in the first instance. Your first is dated the 11th of April 2024. Do you have that in front of you?
I do.
And that statement is reference WITN 098300100. Could I ask you please to turn to page 126?
Yes.
Is that your signature?
It is, yeah.
You then provided a second statement which, amongst other things, clarifies or corrects some parts of your first witness statement. That's dated the 2nd of May 2024. Do you have that in front of you?
I have, yes.
That is document reference WITN 098300200. It runs to 7 paragraphs. Could I ask you please to turn to page 7 of the statement?
Yes.
Is that your signature?
It is, yes.
And can you confirm that, taken together, the contents of those statements are true to the best of your knowledge and belief?
I can confirm that.
Your statement now stands as evidence in the inquiry. They will both be published on the website shortly. I'm going to ask you some questions about them. And I'd like to start, please, with your first witness statement. If we can have that at paragraph 5, page 2 on the screen. So, paragraph 5, you set out your background, and you say, I've been asked to provide my professional background and qualifications prior to joining Post Office Limited. You refer to graduating with a degree in law and French. And then you say, I trained as a lawyer at the European Commission, the Post Office, and DJ Freeman and qualified as a solicitor in 1997. Please, can you confirm when you trained with the Post Office?
For a period of 2 months in the period between 1995 and 1997. Sorry, for a period of two terms of 6 months between those two dates.
And so 2 terms of 6 months, so is that 2 seats, effectively?
That's exactly right, yes.
And what were those seats, what area of law were those seats in?
One was focused on general commercial and competition law, and the other was in intellectual property.
While you were training as a lawyer, as a solicitor with the Post Office, did you have any involvement with the criminal law department?
No, they were, I was aware that they existed, but there was no crossover in our work.
Did you have any discussions with anyone in the criminal law department about their work?
Not to the best of my recollection.
You're going to say that you practiced at Berwyn-Leighton for 2 years, and then you say you were head of European Affairs for Post Office in 1999, again based in Brussels, when you say you stopped practicing as a lawyer. When did you stop practice as a lawyer?
After my stint with Berwyn-Leighton.
So when you were head of European Affairs for Post Office, what did your role entail?
That was policy work and policy and advocacy work.
Did you have any involvement with matters relating to the Horizon IT project whilst in that role?
No, none whatsoever. I was engaged in work concerning the liberalisation of postal markets across Europe.
You then held roles as a civil servant in the Ministry, what is now the Ministry of Justice, correct?
Yes.
And we'll jump to the most relevant time now. You joined Post Office Limited in 2014 as Programme Manager for the Mediation scheme.
Yes, I did.
In that role, who did you report to?
Initially to Belinda Crowe, and then subsequently to Jane McLeod.
And I take it from your earlier evidence that you didn't have a practicing certificate at the time as a solicitor when you were Programme Manager.
That's correct.
And so at no time as Programme Manager did you hold yourself out as a lawyer?
At no time during my time at the Post Office, no.
In June 2016, you became Deputy Corporate Services Director, correct?
Correct.
What role did that entail?
As I think I described in my witness statement, I was chiefly involved in acting as a deputy to the General Counsel, Jane McLeod, for the purposes of management rather than for the purposes of any legal advice she might be giving. She was engaged in a process to integrate various other teams from across the business, so in particular the audit and risk function and information security and information rights. And she asked me to help her integrate those teams into a more coherent whole.
On that, please, could we bring back up your witness statement at page 4, please? Thank you. If we could go to the bottom of the page. You there refer to the role. At the end, you say, within approximately 6 to 12 months of the new structure taking shape, steps were taken to break up the security team into 3 smaller teams, with only the financial crime team looking at money laundering issues remaining within Jane McLeod's wider directorate. While I was not directly involved in this decision, I was aware of concerns at senior level about the prevailing work culture which characterised the team. Please, could you describe what concerns you were aware of about the work culture in the security team?
Yes, of course. I think summary is that it was very old-fashioned and depended on a very command and control type style of management. with the person at the top of that function really, being the determinant of everything. And
just pausing there, sorry. Who at that time was top of the department then?
John Scott.
John Scott. Thank you. Please continue.
So no, it was very old-fashioned and did not conform to what was then the prevailing view of what team management, if you like, effective management, consisted in.
When you were looking at those concerns, or when you were aware of those concerns, were you aware, to what extent did they, to what extent were people concerned that that work culture was affecting the way the security department investigated matters, such as sub-postmasters?
So I'm not sure what the sort of link was between those, between the culture and the practice of investigation, particularly of sub-postmasters. But I think it's fair to say that there was a sense that in some ways the culture was reminiscent of, I don't know, a group of sort of ex-policemen investigators coming together, and that had a sort of particular culture to it, which was a bit of an anathema to what the Post Office was trying to build.
Can you just expand on that? Why was it different to what Post Office was trying to build on?
Well, the rest of Post Office was very open and collaborative by nature. The security team, from memory, sort of acted much more standalone. And sort of seem to enjoy, if you like, being slightly to one side. I dare say there was a sense in which being an investigator was somehow sort of special. But that's about as far as I can go, really.
Well, if you were involved in the restructure, was it not part of your role and responsibility to look what effect that culture had on the actual work that was being carried out by the security department?
No, it wasn't. The decision was taken, and it fell to me to sort of, if you like, pick up the pieces and see, do with the follow through. So, as I say in my witness statement, I didn't take part in the decision. I was somewhat involved in its implementation.
And when did you first become aware of these concerns regarding the security team?
I think quite early on. As soon as they sort of were brought into Jane McLeod's function.
So we say early on. Is that early on in your role in 2014, or early on in when you became Deputy Corporate Services Director?
The latter.
You then, in January 2018, became Corporate Affairs Director, a role that's now known as Government Affairs and Policy Director. Is that right?
That's correct.
And when you became Corporate Affairs Director, how did your role change?
Well, very substantially, in that I was engaged in a range of different issues to that which I'd been previously engaged with. I obviously had been quite heavily involved in particularly the mediation scheme, and so I retained an interest, I suppose, in the work being done in that area. But by this stage, I was also looking at a broader range of issues facing the Post Office, notably in terms of issues relating to our relationship with government, funding questions, around the subsidy, and so on.
The fire alarm may go off at any point, but I'll if we can bring up page 124, please, of your witness statement. Well, we now know we have a working and long-winded fire alarm. If we can, yeah, thank you, we are there. Paragraph 124. I want to look about your approach as programme manager and in relation to the scheme. You say a few lines down in that paragraph, in that regard, so sorry, I should say, you're referring to your involvement in how Post Office Limited handled challenges to the integrity of Horizon by sub-postmasters, members of Parliament, journalists and members of the public. And you say, in that regard, I think the work I was engaged in was conducted in good faith and involved me and others at Post Office Limited doing a significant number of sensible and reasonable things as we attempted to understand and to resolve the complaints and disputes brought forward as part of the scheme. When you say you carried out the work in good faith, what do you mean by that?
Well, I mean by that obviously context is very important in this affair, and we were not imbued with the same knowledge that we have today about what was going on or may have been going on in the background. So, as we were seeing it, the work involved in the mediation scheme, the complaints mediation scheme, was a genuine attempt to try and resolve the complaints brought forward by a relatively small number of postmasters, and I think we did do some very sensible things in order to try and achieve that objective.
In the context of investigations, would you accept that acting in good faith includes keeping an open mind?
As a general principle, yes, but I wasn't involved in any investigations.
I'll rephrase then. In Post Office's work in responding to allegations about the Horizon IT system, when you're responding to them and listening to those allegations, do you think acting in good faith included keeping an open mind about the allegations?
I do, and I think we did. And a number of the documents that have been shared with me and that I've also requested from Post Office Limited show that whilst we had a growing sense of confidence in the operation of the Horizon system as the investigations and case reviews came forward from Second Sight, I record in a number of different places that we should not be complacent. Whilst it was certainly the case that we could draw some comfort from what we've discovered to date, we should not be complacent that would be the final word.
Well, Mr. Bourke, I'm going to explore with you what actually happened. My question is simply, do you accept it involved keeping an open mind? Your answer was yes. Do you accept that acting in good faith also meant acting with transparency?
Yes.
And would you accept that acting with good faith includes acting fairly?
Yes.
When you were brought onto the mediation scheme, what did you understand the objectives of what's been termed Project Sparrow to be?
My understanding was that this was a project established to receive, analyse, examine, and hopefully resolve a number of issues brought forward by postmasters as part of a complaints and mediation scheme.
And your role as programme manager, what did you understand that role to involve on a day-to-day basis?
My role involved ensuring the throughput of cases through the various stages of that, ensuring that the working group that had been set up to look at questions of whether or not cases were suitable for mediation, to ensure that those meetings were equipped with the information they needed to make those determinations, and to, otherwise facilitate the successful conclusion of that project.
And when you joined Post Office Limited, what, if anything, were you told about Post Office Limited's general strategy or approach to responding to challenges brought by sub-postmasters regarding the integrity of the Horizon IT system?
I don't think I was told anything specifically about our approach, just that, we were to consider the cases thoroughly. The investigations would be, or I should say, the re-investigations would be thorough and complete and exhaustive where possible. Obviously, the timing was a bit of a factor in terms of the availability of evidence in some cases, but that we would, do the work to the best of our ability in ensuring that we understood what was really the source of the complaints, and where it was possible to do so, to achieve a resolution through mediation.
I want to look at some examples now of the approach in practice. If we can bring up, please, page 34, paragraph 68 of your statement. And we can see midway down, you're talking here about a briefing note for a meeting with Paula Venables, for Paula Venables, who was having a meeting with MPs on the 17th of November. You say, at the time, there was a sense of frustration within Post Office Limited, about accusations being made in the media and on social media, which did not acknowledge the genuine efforts being made by Post Office Limited to resolve the issues raised by sub-postmasters through the scheme. Did you share this frustration at this point?
I had begun to, yes. It seemed to me that we were doing, as I said in the paragraph you took me to right at the outset, that we were doing some really sensible things to try and get to the bottom of this. We were providing applicants with money so they could properly formulate their applications to the scheme using professional advisors, usually lawyers, sometimes accountants. We were paying for the mediations and the cost of mediations. The investigations were very, very thorough, and we were approaching the question of mediation in good faith.
You'd been in your role for 2 months at that point, hadn't you?
Yes, that's right.
So your evidence is that within a period of 2 months, you'd developed this frustration as to how Post Office Limited was being portrayed in its handling of the scheme.
Well, yes. I mean, I think it got more pronounced as the months went on. But even then, it was clear to me that we were not achieving any sort of cut through in terms of what what our position might be or might have been at the time, because simply we were not being heard.
Please, can we look at poll 20116,790? This is the briefing that we were referring to in your witness statement for Paula Venables. And if we could go down, please, to background argument. Thank you. At paragraph 4, you say, but secondly, we would urge you to stress the fact that you are in charge of an organisation that has, at its heart, the determination to improve people's lives, often the most vulnerable in our society. Indeed, you have obligations in this regard. While the issue being championed by MPs may seem important to them in campaign terms, this pales into insignificance to the bigger social mission of Post Office Limited and your leadership of it, not to mention the literally thousands of people who depend critically on our services. It will be a brave MP who sought to champion one above the other. Was it your view that Post Office's public purpose was more important than the allegations made by sub-postmasters that they'd been convicted and imprisoned in prosecutions that relied on data from Horizon that may have been unreliable?
That's not the question that I was actually faced with. although a number of cases involving criminal convictions had been accepted into the scheme, none of those were taken forward as part of the mediation process.
Well, no, look, what it says is, while the issue being championed by MPs may seem important, one of the issues being championed by MPs was that there may have been unsafe convictions, wasn't it?
Yes.
And so the question is, did you consider that Post Office's public purpose was more important than that issue?
On the basis that I had seen nothing, and the Post Office has seen nothing to suggest that the question of unsafe convictions had any evidence behind them, then I suppose I did at the time feel that.
Was that a commonly held belief within Post Office?
I don't know.
Did Paula Venables challenge it when she received this briefing?
I can't recall.
Do you think that's keeping an open mind to the allegations?
Well, we had had the cases submitted to us, and it was apparent from our reading of them that although there were some suggestions that Horizon may be problematic, there had not been anything advanced to suggest that Horizon was actually responsible for the losses being complained of. So, to that extent, then, it was important to see it in the context, in that context. I would also add that the scheme admitted 150 applications into its number, which is a relatively small number. 136 were actually taken forward as part of it, the others having been resolved prior to treatment. And in the context of the number of users over the relevant period of the Horizon system, which are 500,000, this represented a very, 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 very small minority of cases. So there was certainly an idea in my mind that in the absence of evidence that Horizon had caused the shortfalls, as far as we could determine at that stage, it was important that we retained our focus on the day-to-day mission, while still absolutely addressing the complaints being made, but it couldn't come at the cost of it.
Can we turn the page, please? You refer at paragraph 5 to the Horizon issue being one we are absolutely willing to entertain. And then at 6, you say, but there must be limits. We cannot accommodate the self-indulgence of a number of malcontents to the continuing detriment of our customers. The tiny minority making allegations, while deserving of respect and due process, cannot be allowed to pollute our public service mission. So when you're referring to the malcontents, are they the people in the mediation scheme?
Well, it's a number of, that was the view of a number of them, as it says there. And looking back on this, I clearly regret the rather florid language I've used. But
why did you use that language?
Well, I think it was born of a sense of frustration rather than anything else. And I'm not seeking to excuse it. It's a poor choice of language, but I think it is explicable in terms of the frustration I was then feeling.
What was the self-indulgence that you were referring to?
Well, I think certainly with the cases that we had in front of us in the scheme, there were, in almost all cases, a very rational and frankly quite mundane explanation for what had transpired in those that didn't rely on, theoretical possibilities which were pretty improbable. I think there was a sense in which, in the absence of evidence, to continue pursuing a line which relied on a theoretical possibility rather than the facts in front of us seemed to me to be somewhat self-indulgent.
Please, can we bring up poll 20150-306? And if you could go to page 2, please. go to Nick Wallace's email of the 16th of December. So it's an email to Mark Davis. He asked various questions. The fourth substantive paragraph down, Mr. Wallace says, I get the sense from speaking to a number of postmasters that they don't like the system, they don't trust it, and they live in fear of what the post office might do if they get something wrong with it. If we can turn back to page 1, please, to your response. Go down, please. You start by saying, apart for its breathtakingly facetious tone, it looks to me to be clutching at straws a little bit. Why did you think that Mr. Wallace's email was breathtakingly facetious in tone?
Well, I think if you scroll down to Mr. Wallace's email, and it's the 5th paragraph down, where he says, if you have data which shows that the vast majority of sub-postmasters love using Horizon and trust it implicitly, it would be useful to have that information. I think I took that as being laden with sarcasm, which I think it was. So I was reacting to that in the first instance.
If we can go back up to the email, please. You say, in conclusion, I'm not sure it merits more than a cursory response at the bottom. You then, if we go up, please, to the, thank you, Roderick Williams replies to you, saying, I swear you are the only person I've met more cynical than me, and then by some considerable margin. You respond saying, thank you, sir. I take that as a serious badge of honour, smiley face. You're self-describing as cynical of the allegations being made by journalists regarding the Horizon IT system in this instance, aren't you?
Well, I think up to a point. I mean, look, this exchange, and I know it's come up in a different context. Yeah, obviously it doesn't look good 8 years on, but I think this is the sort of dark humour that is quite often employed in these contexts to relieve pressure. So I don't excuse it, but I think one can read rather too much into it, if I may say so.
But does it show a inherent distrust of the allegations made by journalists and sub-postmasters that you held?
No, it's not an inbuilt distrust. It's not a predisposition to distrust. It's reflective of the fact that there wasn't any evidence for the propositions that were being advanced.
I'm going to move on to a different subject now, and I'm going to look at your involvement in preparing a briefing for a Westminster Hall debate in December of 2014. I'm not going to be asking you any questions that go to the accuracy of matters said within Parliament, simply to your involvement in the briefing beforehand and a document afterwards. I want to start, though, by looking at your knowledge of some matters. When you joined as programme director, what was your knowledge of Post Office Limited's prosecutorial function?
My knowledge was that, like any other company, it had the ability to take private prosecutions. My understanding that the historical position had been that the police had more or less indicated that this was something better handled by the post office, given that there were specific circumstances attaching to the work of a sub-postmaster that post office investigators ought to be more familiar with. And so there was a sort of accommodation as between the police and the post office investigations team that it would take it forward. I was also conscious of the fact that the prosecutions, whilst obviously somebody at the post office had to eventually say yes or no to whether or not charges should be brought, the advice was always provided by external lawyers, in the main Cartwright King, and external counsel. So from my perspective, there were a number of inherent checks and balances in that process.
Are you now aware of, if I said the Simon Clarke advice of the 15th of July 2013 concerning Gareth Jenkins, are you aware of what that is?
I am, yes.
And were you aware of the Clarke advice when you joined as programme director?
No. To the best of my knowledge, I only became aware of the Clarke advice in 2018.
28, sorry, was that 2018?
Yes, 18.
When you were taking the role of programme director, obviously we've discussed already, part of that is looking at or involved applicants who had been convicted of criminal offences, yes?
Yes.
Did you not, did you not receive a briefing on the issues as to that were relevant to the safety of those convictions?
No, I did not.
Did you not ask any questions yourself to satisfy yourself about what Post Office had done to review the safety of those convictions?
No, and just to clarify my previous answer, I was aware that work had been undertaken to review a number of historic matters, but that was the extent of my knowledge of it. For my purposes, the relevant points were these cases going to be admitted into a mediation phase? And I was aware that there had been strong advice from both Simon Clarke and from Brian Alderman, then QC, that such cases should not, frankly, in any circumstances, go into the mediation process. And that is what I took as my lead.
A slightly different question before I move on is, you may not have been, you say your evidence is you weren't aware of the Simon Clarke advice. Were you aware of the underlying allegation that Gareth Jenkins had provided expert evidence in breach of his duties to the court, or expert duties?
I don't believe so. I certainly at some point became aware of the fact that, for whatever reason, and I don't think I was ever clear on the point, the expert witness that we had historically used could no longer perform that function. And I was aware that steps were being taken to explore the bringing on board an alternative. In the event, I don't think that occurred because we ceased prosecutions in 2013 to all intents and purposes.
So when do you say you were aware of the expert witness, or Post Office not being able to rely on the same expert witness?
I can't give you a precise timescale, but it was probably in the, look, at a best guess, and it really is only a guess, sometime around the spring of 2015.
Please, could we, I want to look at remote access now, your knowledge of that. Can we look at poll 3091395? So this is an email from Belinda Crowe, and it goes to you and others on the 20th of October 2014. Could we go to page 2, please? And we see an email that's forwarded to you from James Davidson of Fujitsu, and sets out some matters on remote access. Could we go down the page, please, to 2, where can Fujitsu change branch data without a sub-postmaster being aware of the change? So once created, branch transaction data cannot be changed, only additional data can be inserted. If this is required, the additional transactions will be visible on the trading statement, but would not require acknowledgement approval by a sub-postmaster. The approval is given by Post Office via the change process. In response to a previous query, Fujitsu checked last year when this was done on Horizon Online, and we found only one occurrence in March 2010, which was early in the pilot for Horizon Online and was covered by an appropriate change request from Post Office and an audible log. For Old Horizon, a detailed examination of archive data would have to be undertaken to look into this across the lifetime of use. It goes on to discuss cost. So breaking this down, this tells you, doesn't it, that Fujitsu could insert transactions into branch accounts?
In short, that's correct.
And that when it did that it didn't need to be approved by a sub-postmaster?
It didn't need to be, but in fact, my understanding is that this occurrence, and it says there in the middle of that paragraph, we found only one occurrence in March 2010. My understanding was this was done as part of a pilot, and in fact, the sub-postmaster concerned was fully informed by Post.
Mr. Bourke, my question was it didn't need to be. Well, we can look at the other matters in due course, but I think your answer to that was you agreed it didn't need to be. And you've already said it's been done once for Horizon Online, but the position was for Old Horizon, or what we call Legacy Horizon, Fujitsu couldn't tell you to what extent, if at all, transactions had been inserted into branch accounts.
On the face of it, that's correct, yes.
And at that time, were you clear at all as to whether a sub-postmaster would be able to clearly identify whether Fujitsu had inserted a transaction into the account rather than it being generated in the branch itself?
My understanding is that any such balancing transaction would leave an auditable trail distinguishing that transaction from any performed by the sub-postmaster.
That's slightly different. That's about an auditable trail. I'm saying at this time, did you know whether or not it would be clearly visible to a sub-postmaster on the data that they could access that a transaction had been added into the branch accounts by Fujitsu rather than in branch?
My understanding was if they were to perform the requirements of the task of daily accounting, this would be visible to them, yes.
And where did you get that understanding from?
From Fujitsu.
And how was it going to be clearly visible to the sub-postmaster?
Because it would not carry the postmaster's unique identifier code.
So your understanding is, at this time, that the sub-postmaster themselves would be able to see that data to show that it was somewhere else, or Fujitsu, that entered that data?
They would be able to identify that it was not a transaction which they had entered.
Mr. Stevens, can you give me the date again of that email which provides that answer?
Of course, yes. The date of the email that provided the answer was the 17th of April 2014, and it was forwarded to Mr. Bourke on the 20th of October 2014.
I just wanted to check I got the dates right. So April and October.
Yes, sir.
Yeah, fine. Thanks.
Sorry, I don't know if it would be helpful for me to say at this stage that I think on the 7th of November, so just two or so weeks later, Mark Underwood and I had an exchange of email following a discussion with Fujitsu in which we confirmed our understanding of what was and what was not possible in terms of remote access. And that's the point at which I think my knowledge of these issues really sort of began to form.
Sorry, you dropped your voice with the last few words.
I'm terribly sorry, sir. I was saying that it might just be of interest and helpful to the inquiry to know that there's an exchange of emails between myself and a colleague, Mark Underwood, following a conversation with Fujitsu on the 7th of November, just some 2 or so weeks later, in which we confirmed that our respective understanding of what was and was not possible in remote access terms was aligned to one another and reflected the state of our knowledge at that time.
Fine, thank you.
So I don't propose to go to that, but just for the record, that the reference for that is POL 001494888. That's the emails to which Mr. Bourke is referring.
Right, 001498888?
488.
488, thank you.
Slightly different topic, Mr. Bourke, please. It's still on remote access, but a different element to it. Can we look at POL 203076333, please? Apologies, I'm playing catch up here. So this is an email from Belinda Crowe to you on the 23rd of October 2014. And we can see in the attachments that, there are attachments. It's difficult to see what they are from the description there. But in your witness statement, you refer to one of them, and that's POL 3027153. Now, this is a report for the Post Office Board that is dated on the 6th of June 2014, so before your time, and its authors were Chris Ojard and Mark Davis. Presumably you would have read this, it being sent to you by Belinda Crowe.
So I'm not clear that I would have read it in any great detail. This email was sent to me some 2 weeks after I joined, and to the best of my recollection, the point of it being sent to me was to look at the fact, or to note the fact that advice had previously been taken by Post Office as to the susceptibility of Post Office to a challenge for judicial review were steps taken to move the scheme in-house. So I was not focused on anything else it might have said.
But you're sent 2 attachments, and at this point, I think you are looking to instruct a separate counsel, a separate barrister, to advise on the issue of judicial review. That's at this time, yes? Shortly
thereafter, yes.
So if you're sent 2 documents and you're considering instructing counsel on the same issue, presumably you would have at least reviewed the documents.
Yes, but I would have focused on those bits which were relevant to the work that I was taking forward at the time, which had nothing to do with remote access and everything to do with judicial review.
Well, let's look at page 3. Because this is effectively in the middle of the document. We see it's before the, if you go to the bottom, it's just before the conclusion. Thank you. And then it refers to the Deloitte report and Linklater's advice. And paragraph 5.2 says, as regards the Sparrow-related issues, it is believed that given the limited scope of the work Deloitte were able to undertake, it is highly unlikely that we will be able to extract any further comfort or assurance without their doing substantially more work. Furthermore, it is also clear that Deloitte will not consent to the publication of their report or use their name to publicly assert that the system is working with integrity unless they undertake specific testing. That said, the report does give some comfort for the board on the design for processing and storing transaction data with integrity. You would accept, would you, that the Deloitte report was an important document, that this is Project Zebra. It was an important document in the context of Post Office Limited's response to the applicants in the scheme, or how it approached allegations against the Horizon IT system?
So I was not aware of Project Zebra until much, much later in the context of preparing instructions for Jonathan Swift and Christopher Knight, who conducted the Swift review.
But this document effectively tells you what Project Zebra is, doesn't it?
Well, not really, no. It certainly doesn't go into the findings, and it wouldn't have been apparent to me that there was a project called Zebra, or that Deloitte had been particularly instructed to look at anything in particular. As I've previously said, the purpose of this document being shared with me was to inform my consideration of whether or not instructing counsel to provide advice on the susceptibility of Post Office as it might seek to change the scheme was susceptible to judicial review. So I wasn't looking at it from the purposes of data integrity or the Deloitte report.
Well, just a few days earlier, Belinda Crowe had sent you sent you the email regarding remote access, correct? You've just been to it.
Yes, I mean she would have. Yes, she may well have sent me an email on remote access. Yeah.
And at this time, you are dealing with, as we say, applications in the scheme. If you read this and saw, that said, the report does give some comfort for the board on the design for processing and storing transaction data with integrity, surely you would have considered that to be relevant to the work you were carrying out.
Well, up to a point, though I was not at that stage focused on questions of data integrity. As I've said, and I say again, I was looking at this from the point of view of the susceptibility of Post Office to a JR should we change the scheme. I think I'm right in saying that the email that I was sent by Belinda Crowe, to which you refer, was sent to me on the 23rd of October of that year, which is perhaps week 5 of my arrival at Post Office, not knowing the subject matter terribly well. So I'm afraid if I'm guilty of having, not immediately seen the relevance of all these things at that time, then I can only apologise. But I don't think it's.
Let's look at it in context. You receive the email on remote access from Belinda Crowe a few days before, so remote access on your mind. Your earlier evidence, you referred us to a conversation you had with Mark Underwood on the 7th of November regarding remote access. Is your evidence that when reading this report here, on or around the 23rd of October, you simply put issues of data integrity out of your mind?
Well, my evidence is that I wasn't focused on that point, and the email confirming my understanding of what was and was not possible in relation to remote access and the exchange between myself and Mark Underwood dates from the 7th of November, sometime after the 23rd of October.
Please could we go back to the issue of remote access and POL 20149598, please. Thank you. Now, if we can go down to the bottom of this page, please. We see there's another email exchange. Well, sorry, it's an email exchange between you and James Davidson at Fujitsu. And presumably this was arising from your work with Fujitsu to establish the position in respect of remote access?
Yes, it reflects my growing involvement in issues of remote access, yes.
You say in this email, we absolutely share the ambition to put the baseless allegations brought forward by Second Sight and applicants where they belong, but there's a bit of handling to be done. Where did the allegations belong?
Well, they needed to be taken at face value, but need to be examined for any evidence to support them, like any other allegation. And as the expression baseless allegation suggests, that allegations were certainly being made, but very little evidence was being adduced in support of those allegations. So that's the point I was making.
Was your approach, would you say this is an open-minded approach to the allegations being made by Second Sight?
I don't think it's a closed approach. It's an approach that requires Second Sight to do more than just allege things and to provide evidence for those allegations. I don't think that's in any way unreasonable.
Well, you'd been told, hadn't you, that inserting transactions into branch accounts was possible? Yes?
Yes.
And you, at this stage, didn't know to what extent, if at all, that feature had been used in Legacy Horizon?
I mean, that is true. I didn't even know if that facility existed in Legacy Horizon.
So how did you come to describe the allegations as baseless?
Because when we were looking at the cases in the scheme, and please, I mean, just for the sake of context, my only involvement with the cases in the scheme, in none of those cases could it be said that remote access was responsible for the losses being complained of. And we know that because of another exchange with Fujitsu, in which they reported, because we asked them to identify whether or not any such remote access had taken place. And the answer came back not once but twice, with the final answer coming back saying, everything appears golden.
So your evidence here is that you're not referring to the general allegation made about remote access. This is, you're saying this is allegations in individual cases within the scheme.
That was the work that both we and Second Sight ostensibly were focused on.
Let's now look then, I said this would be about a briefing. Let's look at the briefing and how that was created. I think you accept in your evidence that you were asked to assist UKGI, the shareholder executive, prepare a briefing for Joe Swinson on the 11th of December 2014.
Yes, that's right.
Could we look, please, at poll 00150097? Now, this is one of the drafts of the briefings you prepared. I mean, if you look at paragraph 77 of your statement, you say that, we don't need to bring it up, you say that you shared an early draft of this document with Belinda Crowe, Andrew Parsons and Mark Underwood on 12th December 2014. So did you draft this document?
I would have drafted the draft, yes.
If we look, please, at page 3. Sorry, bear with me. If we could go down to just show what... Yeah, that's perfect, thank you. It says, what were the main accusations of the interim report? That's referring to Second Sight's interim report, isn't it?
Yes, the interim report of 2013, I think.
And you write under other conclusions were 2 incidents where defects in the Horizon software gave rise to 76 branches being affected by incorrect balances or transactions, which took some time to identify and correct, but which were corrected. Using the word incident, was that a word you used yourself, or did you receive guidance on it?
I certainly didn't receive guidance on it. I think that's what I would have chosen myself.
Do you think that fairly reflects the points made about the receipts and payments mismatch bug and the suspense account bug in the interim report, to describe them as incidents?
Well, if you read the sentence, it's 2 incidents where defects. So in fact, I'm talking about defects in the Horizon software, not incidents in the Horizon software. I think defects is, whether you want to call it a bug or a defect or an anomaly or an exception, I'm not sure it really makes much difference. The point is that there was a problem with Horizon software which gave rise to these issues.
Could we look at the next, well, a further version of the draft briefing, please? It's UKGI 402719. And page 4, please. If we could go down to progress result, thank you. It says, what were the main accusations of the interim report? And it now says, though Second Sight identified a number of areas of concern that needed further investigation, it must be noted that their primary finding was one of no evidence of system-wide problems with the Horizon software. Can you recall why the further information in your earlier briefing was taken out?
I have no idea. I'm not sure. I mean, maybe it was just for the sake of brevity, but the basic conclusion at the second bullet point you've just read out is accurate.
Do you think that's a full and fair briefing of what was in the interim report for the Minister?
Insofar as the Horizon system is concerned, yes.
So your evidence is that it wasn't important to highlight to the Minister that the interim report had included information about at least two bugs in the system.
The bugs that were reported by Second Sight were not new. We had in fact told Second Sight about those 2 bugs on a voluntary basis. So,
Mr. Bourke, can you answer the question, please? The question was about the briefing. Did you not think, is your evidence that you didn't think it was important, or the Minister shouldn't be informed of the 2 bugs in the interim report?
Look, in circumstances where it was not new information, and it had been satisfactorily resolved, at that time I clearly didn't think that, if indeed I was the author of this final version.
Well, I was going to ask you, do I understand your evidence to be that the first draft that we looked at, you accept the probability that you were the author, whereas are you accepting that you were or may have been the author of this draft?
I think what I'd say, sir, is that as with all briefings, particularly ones going to ministers, there is a sort of process of quality assurance that would typically involve people more senior than the original draftsman. And I suspect that's what happened in this case. So although the initial words and the working draft would have emanated from me, the final version that went would have had the approval of people more senior than myself.
Yeah, I follow that, but without displaying too much ignorance, I'm not sure, as I sit here at the moment, which paper eventually went to the Minister. So that or simply trying to get a sequence right, if you see what I mean. So again, can I just be clear? The first draft we looked at, you probably did author. Is the state of your evidence that you don't know whether you authored this one? Or do you know, whichever it is?
I authored this one as a draft. The final version, and this may or may not be it, was, authored.
Sure, right. So that simply so I can be clear in my mind, I'll use the phrase, the probability is. The probability is that you did author the two drafts that we've looked at so far.
Yes.
So,
right. Fine.
So at this point, I think if we can look at actually, in fairness to Mr. Bourke's evidence in his witness statement.
Right, yeah, please.
Page 42, paragraph 81. So we were looking at UKGI 402719, which you see, sir, is the URN at the end. And we see the evidence there that it appears shortly before this at 11:13, he, referring to Mark Underwood, had shared the same version of the briefing document with me and Belinda Crowe in a separate email chain. And at 11:19, I forwarded this to Richard Callard with both Belinda Crowe and Mark Underwood in copy. And so there's then evidence on various drafts that went backwards and forwards.
Yeah. Anyway.
It may help, say, if I'll go to this, because this was going to be a question I had, is if you can look at POL 20150316. Mr. Bourke, are you able to assist us with if this is the final version of the report for the Minister?
No, but it looks like a near finalised version if it's not the final version. Just by way of clarification, briefings for ministers are drafted and finalised by civil servants rather than by people at the post office. So we would have provided a great deal of material, but the final package that was communicated to, in this case, Joe Swinson MP, would have had the approval sign-off of whatever the appropriate management chain was in the civil service of that department.
Yeah.
Please, can we look at page 4 of this document? We have a question about why did Post Office agree to incorporate convicted cases into the scheme if it knew it wasn't going to mediate? And we see the fourth bullet point down. It says Post Office is, however, under an absolute duty to immediately disclose any information which might undermine the prosecution's case or support the case of the defendant, and Post Office has done so where appropriate. And can you recall if you took any advice or were involved in the drafting of this section of the report?
So I don't recall, but it was my practice certainly to consult people in the legal team whenever matters around matters of criminal law, which I was really very unfamiliar with, were concerned. I think, and I don't know whether it's helpful to the inquiry to know, but the question of as to why criminal cases were first allowed into the scheme, if indeed the prospect of mediating them was highly unlikely, I think may have been born of a desire to, if you like, get the scheme up and running. In any event, although those cases were not mediated because we had had very strong advice that they could not be, it would nonetheless enable the applicants to benefit from a full re-examination and investigation of their cases and a criminal case review, a case review report from an independent firm of forensic accountants, such that it could be used by them in the, if they decided that was the thing to do, to lodge an appeal against their conviction. So it was an entirely pointless exercise for them to be part of the complaint and mediation scheme, even if the mediation did not take place in those cases.
Do you think around this time, as part of your involvement with creating this briefing, you would have been made aware of the difficulties with Gareth Jenkins' evidence?
I think it's unlikely because this is still, to the best of my knowledge, late 2014.
Yes.
This whole debate took place on the 17th of December. And I, in an answer I gave at the beginning of this session, I think told you that that sort of knowledge began to emerge for me sometime in the spring of 2015, although I wasn't aware of the details. I'm not sure I even knew the identity of Mr. Jenkins at the time, just that there had been a problem which rendered the previous expert as being unusable in future proceedings, and some work being conducted to explore the possibility of an alternative expert being found to effectively provide the same expertise in any future cases.
I want to look at the last two documents before we'll have a short break. Poll 20308923, please. If we can go down to the bottom of the page, please. Thank you. We see your email to Richard Callard, shareholder executive. He was the shareholder non-executive director at that point, wasn't he?
He was, yes.
And it says, Richard suggested responses to the additional questions prompted by, presumably that's Joe Swinson's chat with now Lord Arbuthnot, James Arbuthnot. Is that right?
That's my reading of it, yes.
And see, for the sake of expediency, I'm copying internal colleagues for their comments, please. I'd be particularly grateful for the views of John Ale on the criminal aspects of this, and Andy Parsons to check I have done the statute of limitation bit justice. And if we go up, please, we see John Ale Singh then sends a response to you, and it looks like that's internal to Post Office, and Richard Callard isn't included in the copy list.
Yes, with the exception of Andy Parsons, who was obviously not in.
Yes, very fair point. Sorry, I was focusing on Callard, but yes, and Andrew Parsons is there. Can we look, please, at the... Oh, sorry, he says, please see my notes and comments in red. Can we look at those? That's poll 3040517. And one of the questions we see is destruction of documents relating to cases in the scheme. And presumably the first point, which isn't in red, Post Office has not and will not destroy any documents relating to cases in the scheme. That was written by you, was it?
It would have been written by me on the basis of information supplied by somebody else, because my understanding of retention periods would have been limited at this stage.
If we look at Mr. Singh's comments, if we could just go down slightly, refers to data retention policies. It says the implied suggestion that this is unwarranted is incorrect. CK Cartwright King should be advised Post Office Limited not to shred/destroy documentation after such an instruction was given in the security team and following publication of the interim second sight report. Do you remember reading that?
I don't particularly, although I do know what it refers to now, yes.
Would you have read it?
I almost certainly, yes. To the extent that I would have really engaged with it, I'm less certain. I can't. My recollection just isn't strong enough to tell you.
Well,
sorry.
It's very important, isn't it? Because what we're talking about here is the question is about destruction of documents relating to cases in the scheme, and Mr. Singh is saying, or alluding to advice about an instruction being given to the security team to shred/destroy documentation. Would that not have set alarm bells ringing?
Yes, no, absolutely. I don't know whether I had alarm bells as a result of this particular correspondence, but certainly I became aware that an instruction was given not to the security team, but within the security team. But my understanding was that nothing of the sort in fact transpired, and there was a great deal of consternation that it had ever been thought appropriate to give in the first place.
Where did you get that understanding from?
I don't particularly recall, but it would have been in conversations with other people engaged in this work. So any number of people, including Rod Williams, Belinda Crowe, Mark Underwood, Andy Parsons, and so on.
Did you pass on this allegation or otherwise inform Richard Callard or anyone at Shareholder Executive?
I don't recall.
Do you think you would have done?
I think probably, yes, because I think whether I did or somebody else did, I think it would have been shared with them on the basis that this was something that was clearly inappropriate and was likely to generate adverse comment, as well it might.
And that's my question, just a further gloss on it. With this information, do you think it should have been passed on to the Shareholder Executive?
I think probably, yes.
Thank you. So that's probably a good time to have our morning break.
All right. What time shall we resume?
11:15, sir.
Okay.
Thank you.
Thank you.
Good morning, sir. Can you see and hear me again?
Yes, I can. Thank you.
Mr. Bourke, can you see and hear me?
I can. Thank you.
Good. Please, can we move on slightly to after the Westminster Hall debate? Could we look at poll 20351025? And if we could go down to John L. Singh's email of the 8th of January. So this is the 8th of January 2015, and Mr. Singh is providing some comments on BBC Inside Out request for an interview. And what Mr. Singh says, we see second paragraph, whilst Post Office wish to say there are no systemic faults, the second sight interim report, which has been disclosed to the defendants and their legal representatives, does mention 2 defects/bugs which give rise to 76 branches being affected by incorrect balances or transactions. A bit further down, it says it also raises questions as to whether Post Office Limited knew of the existence of those bugs. If so, to whom at Post Office Limited Fujitsu communicated them? Those were certainly not known to me at Post Office Limited Legal until a day or so prior to the publication of the second site interim report. The difficulty here is made worse by the fact that Gareth Jenkins, an employee of Fujitsu, has been making statements for use in criminal proceedings which made no references to the very bugs which it is understood he told Second Sight about. People were prosecuted and pleaded guilty following the receipt of his statement, which implied no bugs had been found. We see, I should have said, you're CC'd into this email. Presumably you would have read this at the time.
I imagine so, yes.
So would you accept that when we, earlier you couldn't quite place a date on when you were aware of the issue with Gareth Jenkins, that you were aware of it or would have been aware of it in 8th of January 2015 at the latest?
I think in theory, yes, that's right.
We say in theory is
well, sorry. Yes, I mean, I was a recipient. I was the copy recipient of this email, and whilst I don't have any sort of very clear recollection of having read it in any great detail, as a matter of fact, yes, you're correct.
Please, can we look at UKGI 402944? Now, we don't need to show this on the screen, but sir, for your reference, and Mr. Bourke, for you as well, at page 48, paragraph 93 of your statement, you refer to this document and you say, on the 13th of January 2015, I shared a draft of Post Office Limited's response to the Westminster Hall debate with Richard Callard, and you give the URN, so the unique reference number for the email, and later on this document we're looking at. And this was, as I understand it, effectively a further briefing document to deal with matters that had been raised during the Westminster Hall debate. Is that right?
So I think after the Westminster Hall debate, from memory, what we tried to do was to collect all the allegations that had been made during the course of that debate, and others which we had obviously had from other sources, with the purpose of developing a more comprehensive document to address each and every one of those. From memory, I think there was envisaged to be 2 such documents, one a sort of rather briefer one intended to be used in more sort of general communications, and then a longer, more granular one intended to inform members of Parliament. The response was the product of a collaborative effort on the part of a fair number of people, from, as I think I made clear in my statement.
And presumably this document runs to 15 pages. Is this the longer document, the more granular one, as you described?
I think it must have been. I think Tom Vexler, who was working with me on the scheme and interface for the working group, started this process, and at some point I took over the task of bringing it together as a sort of briefing coordinator, which was not atypical of my role at the time.
So briefing coordinator, would that include ensuring that different parts of the business or subject matter experts who would contribute to the briefing on areas where their subject was in issue?
That's correct.
And given you sent it to Richard Callard, shareholder executive, on the 13th of January 2015, do you take responsibility for its contents?
No, because it was a collaborative effort. So I wrote it and I edited it, but the specialist content, which I solicited from other colleagues, really belongs to them.
So when you say no, do you take... is it fair to say if you were told a matter, say you were told X on a subject matter, you would be responsible for including that in the response, but you wouldn't be responsible for the accuracy of what was provided to you by the subject matter expert?
That's a more accurate description, yes.
Could we look at page 10, please? At paragraph 40, you say, to date, no evidence has been identified by Post Office as part of its reinvestigation of each and every case, nor advanced by Second Sight or an individual applicant, to suggest that the conviction of any applicant to the scheme is unsafe. If we can go over the page, please. Sorry, to page 12. There's a section on approach to prosecutions. See, 51 talks about the power of prosecution as a private individual. 52 is interviews under caution. When we get to 54, it says all cases of potential criminal misconduct are thoroughly investigated and decisions about appropriate courses of action are taken on the basis of the available facts and evidence. This goes on to say, when Post Office decides to prosecute a case, its conduct of the prosecution is scrutinised by defence lawyers and ultimately by the courts themselves. If we could go over the page. On 56, once a decision has been made to prosecute, the Post Office has a duty to disclose the evidence against the suspect, along with all evidence that would assist the defence or undermine the prosecution. As the Post Office refutes the allegation that it's put pressure on defendants to plead guilty, sometimes to lesser offences. Why did this briefing not include reference to the issues with Gareth Jenkins?
That's a fair question. I think this document, I'm not convinced I was aware of the issues around Gareth Jenkins at the time. But in any event, as we've just discussed, the content where it relates to specialist issues, particularly around matters of which I really know nothing about, i.e. criminal law and procedure, I would have relied entirely on the advice I was given by the legal team.
And who in the legal team would you have relied on?
I would have relied on, I expect, John L. Singh, but more particularly, the advice that he was being, he was effectively the conduit between the Post Office and Cartwright King, our external legal providers. So that added, to my mind, a measure of reassurance that there was an internal, independent organisation with its own professional standards of ethics and responsibilities.
Well, let's just focus on, you said John L. Singh and referred to Cartwright King. If you would refer or rely on John L. Singh, we've seen as at 8th January 2015, John L. Singh was raising the issue with Gareth Jenkins with you on an email. So can you explain, in those circumstances, why there is no reference to Gareth Jenkins in this report?
I'm sure that briefing would have been circulated to those people once more prior to its finalisation. So
Mr. Bourke, earlier I asked you of the difference of responsibilities. One is the subject matter itself, which you accepted was, or you said was a matter for the subject matter expert. And the second one is if a subject matter expert tells you of something, you accepted responsibility for seeing that that makes its way into the briefing. Do you not accept that?
Well, I do, but you get...
Okay, so in those circumstances, why in this briefing is there no reference to Gareth Jenkins?
I'm not sure.
Well, is it because you didn't want to highlight the problem with Gareth Jenkins and past prosecutions?
Absolutely not, no.
Well, what other explanation is there?
As I tried to advance a second or two ago, each one of these exercises sees me fairly methodically consulting people around the business, and the finalisation of this text for this document would have been okayed by our criminal law team. So insofar as there were good reasons or other reasons to exclude it, they would have fallen to them to take.
Can I just be sure that I'm clear about its intended purpose? Was this a document prepared for dissemination internally in the post office? Or was it a document intended ultimately for Mr. Callard in his role, which was shared internally in the post office before it got to him? Or was there some other purpose that I haven't yet heard about?
I think I'm right in saying that the impulse was we had had a lot of accusations made against us, and we wanted to actually produce a more comprehensive piece. The ultimate purpose to which that would be put, I think, was still in question, but certainly it would find its way to Mr. Callard, who would...
Right. So at least one of its purposes was to provide, obviously, accurate information, one imagines, to Mr. Callard. Fine.
Could we actually bring the briefing back up? It's UKGI 402944. And if we could look at page 11, please. Well, I'll check with the witness. The chair asked, it's now gone off my transcript. Can you, Mr. Bourke, can you, did you give an answer to the chair's question, his last question?
I believe so, yes.
What was that answer, please, just for the transcript?
So he asked me whether at least one of the purposes in the preparation of this document was to provide information to Richard Callard at UKGI, to which I replied yes.
Thank you. I apologise. I'll try to make sure if I spot a nod, I get it recorded on the transcript.
Sorry, I should have confirmed Mr. Callard's agreement with the premise.
No, so I'll take sole responsibility.
Mr. Callard, I'm getting confused now. Mr. Bourke.
Yes. Right, we're on page 11 of this briefing. If we could go down to paragraph 48, please. We see here we have remote and malicious access to branch accounts. So during the debate, it was suggested that sub-postmasters' accounts can be amended remotely in Horizon without their or their staff's knowledge. There's no functionality in Horizon for either a branch, post office, or Fujitsu, suppliers of the Horizon system, to edit, manipulate, or remove transaction data once it has been recorded in a branch's accounts. It is possible for Fujitsu to view branch data in order to provide support and conduct maintenance, but this does not allow access to any functionality that could be used to edit recorded transaction data. Post Office can send transaction acknowledgements, TA, or transaction corrections, TC, to branches. Now, pausing there, transaction acknowledgements and transaction corrections both require the sub-postmaster to accept them. Do you agree with that?
That's my understanding, yes.
TAs are used to record transactions that have been processed in branch through other systems, and TC, transaction corrections, to correct errors made by branches. Both TAs and TCs need to be accepted by a user logged into the branch Horizon terminal before they are recorded in the branch accounts. They are therefore fully visible to each branch. There is also no evidence of malicious remote tampering, and the suggestion made during the debate that a secretive team at a post office location is engaged in this sort of activity is flatly denied. Why did you not refer to what was called balancing transactions, which we discussed before, namely where a sub-postmaster didn't need to accept the insertion?
Yes, look, I mean, I think that's a good question. As I've indicated previously, all of these briefings were the product of collaborative effort by internal and also external advisors. From recollection, the view taken or the view advanced by Womble Bond Dickinson, or Bond Dickinson as it then was that the balancing transaction was, there having only been one instance of it where the postmaster had been informed, it didn't merit inclusion. Now, in retrospect, I think that was a mistake and we should have included it in this briefing.
Well, let's pause there. The one instance that you were aware of was in Horizon Online, wasn't it?
Yes.
And at this stage, did you know, or had Fujitsu told you how, if, or the extent to which a similar matter had been used in Legacy Horizon?
No, they hadn't, and I'm not even sure that that facility existed in that system. I think from memory, a conclusion was drawn that, or I think on the advice of Fujitsu, that to conduct that sort of retrospective analysis would have been immensely lengthy, complicated, and ultimately expensive, and was disproportionate to the task.
So how could that then have been a justification that you thought it had only been used once in Horizon Online, not to mention this potential avenue of remote access when you didn't know the position in respect of Legacy Horizon?
Well, as I say, the only time balancing transactions were brought to my attention was in the context of HNGX, the Horizon Online. There was no discussion that I recall about whether or not that facility had been used, was available, and indeed had been used in the previous version of Horizon, and it just wasn't part of our considerations at that time.
But we referred to emails earlier where it was raised, and you've just said in your evidence that it was ruled out as being disproportionate. Is that not right?
I did say that. That's my recollection. I can't be absolutely certain about the way it was put to us, but the advice we had from our external legal advisors was that balancing transactions were had been exceptionally rare to address a particular anomaly. The postmaster be informed, and in those circumstances, it was not a credible avenue or it was not a material avenue to pursue for these purposes. Now, in retrospect, as I've said, I don't think that was the right call. And if I had my time again, I would have disclosed it. Or I would have included it in this briefing.
I mean, in summary form, to give a complete, in inverted commas, picture of Horizon Legacy and Horizon Online, you would have included the balancing transaction point in relation to Horizon Online, and you would have included a statement saying we don't know whether the function existed to do the same on Horizon Legacy or Legacy Horizon.
That's absolutely what we would have, what I believe we probably ought to have done with the benefit of hindsight. At the time I was preparing this document, I was 3 months into the job, and I didn't
Yeah,
think.
no, I follow why you say it didn't happen, but that's the reality of it, isn't it?
Absolutely, and I'm very happy to say that if I had my time again, I would have included both those things.
Please, could we bring up poll 203107661? And if we could go to the second page, please. We'll see when we scroll up in a moment. Thank you. This is an email from you to Roderick Williams on the 20th of January. And you say you were going to send me BA Brian Altman QC's reports. Would you mind when you get a chance? Why were you asking for those reports at that stage?
I think it was in preparation for the response to the Westminster Hall debate, and I think I was in the process of assembling the documentation that demonstrated that a number of reviews had taken place, although I did not know the precise scope or the extent of those reviews. But I wanted to, I knew some had taken place, but I'd never actually seen any of them.
So if we go up, please. We see Roderick Williams sends that on the same day. So apologies for the delay, 4 advices attached, interim review, general review, and 2 others. Did you read those advices when you received them?
I don't believe I did, actually, in actual fact. There's quite voluminous set of material related to historical matters, and my chief objective in obtaining them, I think I'd first asked for them in December, was in making sure that we had all the constituent parts available to us in the context of what we thought were likely to be more requests for information.
What is the purpose of having all the constituent parts together if you're not going to read the advices?
To ensure that their availability, should they become relevant, or should we need to deploy the actual, the actual documentation at any future point?
Presumably, you thought they may have been relevant by asking for them.
I wanted a complete set, yes, of what I'd understood to be a number of reviews that had taken place into past prosecutions, and indeed advice on our prosecution processes.
So your evidence is this was just to have on hand if the need arose, despite the fact you were dealing with you previously settled a response document that covered things like Post Office Limited's prosecutorial practices. Is your evidence really that you didn't read these advices?
I certainly don't think I'd read them in any great detail, no. They're quite specialist in nature. I may have read some of them. I don't think I would have engaged them with any degree of real application, if I may say so.
Well, let's look at POL 406581. This is the general review by Brian Altman KC. It's dated the 15th of October 2013. Could we please turn to page 5? Now, if you said they were lengthy documents, do you think you would have read the executive summary?
Quite possibly, yes.
If we turn, please, to page 6 and Roman numeral 10. It says, I agree that Gareth Jenkins is tainted and his position as an expert witness is untenable, thus a new expert should be identified as soon as practicable. Following receipt of this advice, did you tell Richard Callard or anyone at Shareholder Executive about the issues relating to Gareth Jenkins?
No. These were matters for the legal team to act upon. I think this was 2015, sometime after this review was conducted, and certainly post any prosecutions by Post Office. So no, not because of lack of care. It just simply wasn't something that fell within my area of expertise or area of responsibility. There was nothing to suggest to me that this advice wasn't acted on by the people at the Post Office who you'd expect to act upon it. So the General Counsel, the criminal lawyers, and so on. So, no, I didn't. That's the short answer.
Did you have any indication as to whether or not Richard Callard or others at Shareholder Executive knew about the issues relating to Gareth Jenkins?
I don't know off the top of my head, but I think it would be difficult to imagine that they weren't aware of the fact that prosecutions could no longer take place on the basis of an absence of an expert witness to attest to the robustness or otherwise of Horizon. So I think it would be difficult to imagine that they weren't aware, at least, of the fact that we couldn't, at that time, prosecute because we didn't have the requisite expert.
Mine's a slightly more precise question, which is, if do you have any knowledge as to whether anyone at Shareholder Executive knew of the allegations against Gareth Jenkins, namely that he'd acted in breach of his expert duties?
I don't have any direct knowledge of that, no. I just posited what I think probably would have happened.
Okay, I want to go to a different topic now and look at the closure of the mediation scheme. Please, can we bring up poll 2049669? We don't need to have this up, but so for your reference and also Mr. Bourke, for you, at page 35, paragraph 71 of your statement, you refer to this as a note of advice for Paula Venables that you prepared to inform her consideration as to how to respond to the proposal advanced by MPs that Post Office Limited mediate all cases in the scheme, where this was recommended by Second Side. So if we can see immediately from the recommendation is to decline to that proposal. Could we go down, please, to paragraph 4 for the reasons? So paragraph 4 effectively says it's not something that Post Office Limited could accede to or agree to mediate all cases, because it would require mediating criminal cases. Is that a fair summary of the reason?
Yes, on which we'd had strong advice. But...
Yes. Paragraph 5 is a slightly different reason. It says it would also necessarily entail the mediation of cases in which Post Office Limited is not, on any reasonable view, responsible for the losses or other complaints it is alleged to have been the cause of. So this is non-criminal or court cases, but Post Office doesn't want to mediate all of them because on the merits, there'll be some that it considers aren't worth mediating. Is that a fair summary?
I'm not sure worth, but I mean, there just simply wasn't anything to mediate because the facts pointed to a very clear conclusion about the responsibility or otherwise for the loss.
Okay, well, I won't explore what the distinction there's supposed to be, but was that view in paragraph 5 the view of the entire team, or an agreed view of the team who were working on the scheme?
To the best of my knowledge, yes. As we looked at the cases and the CRs being produced by Second Sight, it was a difficult conclusion. It was difficult not to reach that conclusion.
Can you recall if Paula Venables accepted that advice and agreed as well?
Not specifically, although I think she came to share the view which those of us closer to the subject matter had reached earlier, that all was not straightforward in Second Sight's advice.
Can you just explore that when you say she came to the view? And was there a difference of opinion at the start?
I think that's right, and I think in my witness statement I referred to the fact that I had written in some briefing that I'd come to the view that Second Sight's impartiality was questionable, and she had picked me up on that. But in the immediate aftermath, both Mark Davies and Tom Vexler provided support for that contention, having seen cases. So she had formed the view that it was too strong a claim to make on the basis of some of the early case review reports. But having read more of them and seen, having been involved for a longer period, she came to share that view.
We might be talking at a slightly different point. I think we will come to that briefing in shortly. But my point is, do you recall if Paula Venables accepted the advice that Post Office Limited shouldn't agree to mediate all cases because some of them did not merit mediation?
I believe so, yes.
Please could we bring up poll 20149-683. Now, for context, we don't need to have it on the screen, but at paragraph 72, page 37 of your statement, you say on 26th November 2014, you prepared a corresponding update, so corresponding to the last one we saw, for Alice Perkins in advance of a trip she was making to a conference in Turkey. And if we go to paragraph 2, please. That advice is now with the CEO to refuse this suggestion. We know that's the position of accepting all mediations, not least since it would entail the mediation of criminal cases, on which we have advised in the strongest terms that to do so would subject Post Office Limited to intolerable risk. And it goes on to say it would necessarily entail the mediation of cases in which Post Office Limited is not, on any reasonable view, responsible for the losses or other complaints it is alleged to be the cause of. So it's basically the same as advice you were giving to Paula Venables, wasn't it?
Yeah, as I say in my witness statement, this was drawn largely from the document I'd prepared for Paula Venables for the previous engagement.
And can you recall if Alice Perkins accepted that advice?
I believe so. She, I think, wrote an email to summarise her encounter with James Arbuthnot in Ankara, in which she certainly gave every indication that she had taken the briefing to heart.
I'm just going to take a brief segue at the minute for chronology purposes, but we'll come back to those briefings. Could we please bring up POL 20149685. So it's an email exchange between you and Tom Vexler on the 26th of November 2014, so the same day on which you say you drafted the briefing for Alice Perkins, yes?
Yes.
And this is, I think, shortly before a conference you were going to have with Tom Weiselberg KC on the prospects of a judicial review of matters in relation to the mediation scheme if there was an amendment.
That feels about right. I can't remember the exact date.
If we could go down to the bottom email, please. Mr. Vexler says, subject, he was sat next to me, back covering in full effect. Your response obviously shows you're not, there's a degree of upset about that. And you say, unfortunate that he bumped into Alice before Mark and I collared him. I feel for RW a bit. Is RW Roderick Williams?
I would imagine so.
Now, when we're saying he was sat next to me, who is this referring to?
I have looked at this email over and over again in preparation for this inquiry, and I just simply cannot remember who it was we were referring to.
If we look up, please, to the next email, again from Tom Vexler. It's teaching you to suck eggs, but I laid the ground for the way out of this with honour preserved. Although there is a fundamental difference of view on public/private law point, circumstances have changed markedly. So do we take from this that whatever embarrassment had been caused, it was related to the public law advice in some way?
I think it may have been, as I think I referred to in my witness statement again. There had been previous advice obtained by Post Office before I joined, so in the summer of, I think, 2014 from Beat, and the partner, I think there was Stephen Hocking, who had come to a different conclusion about the susceptibility of any decision in relation to the working group or the scheme more generally than the advice that we subsequently received from Tom Weiselberg. And I think there was a bit of an issue around how those two bits of contrasting advices could be reconciled with one another. And I think I'm right in saying that Tom Vexler was advancing the point that the passage of time and the events that had occurred during that time did point to a new set of circumstances which might offer some part explanation for that distinction.
Well, with that background, who do you think this may refer to? Who are the list of potential candidates to whom it could refer?
I genuinely can't remember. I mean, I suppose if I'm right about the awkwardness of contrasting advice, one set obtained by me, by my team in November, and the other obtained by Post Office in the summer. It may have been Chris Orjard, but I just don't know.
In Tom Vexler's email, below the main paragraph, he says, coming up with a new version of history, not just on this, will be key to, e.g., ensuring that nothing sticks on AP/PV. Presumably that's Alice Perkins and Paul Venables.
That's my understanding, yes.
When blame is being apportioned. Was this common practice within Post Office to rewrite history?
Not in my experience, absolutely not, no. I mean, you'd have to ask Tom Vexler why he used that turn of phrase. It certainly wasn't mine.
Well, if you look above, you say, thank you, we'll call later on. You didn't object to the turn of phrase at the time, did you?
Well, no, but if I objected to every turn of phrase that I thought was slightly off, no, I didn't, but I just got on with it.
Do you recollect how this matter was resolved, or any call you had with Tom Vexler?
No, I don't.
Right, let's move on back to the mediation scheme. Can we look at poll 406575, please? So we have a minute from the Sparrow subcommittee meeting on the 12th of January 2015. I think the inquiry has seen a different version of this with an incorrect date on at one point, but this is 12th of January 2015. We see at the bottom, you are in attendance. And looking at summarising the points to consider, it said the committee received a paper on the position of the scheme and discussed steps to be taken. C, Mark Davis explained the recent Westminster Hall debate. Chris Ojar reported changes in business processes regarding prosecutions. There was then the judicial review advice provided by Tom Weiselberg QC, and a discussion over whether it was inconsistent with the Beechcroft advice. Chris Ojar saying it wasn't. And then F says the committee discussed Second Sight and their Part 2 report due to be finalised in April. The committee agreed that the business was unlikely to be able to stop this report from being produced, but should press Second Sight to complete the individual case reviews by the end of March, i.e. giving the cases priority. So at this meeting, was the Sparrow subcommittee exploring ways to stop Second Sight producing its updated Part 2 report?
I don't think so, in the sense that I think that F records the fact that insofar as they once had, that ship had sailed, and they were reconciled to the fact that it was going to emerge. I think there was a concern, because the Part 2 report had been very long in gestation, that actually the delays the scheme occasioned by the focus on the Part 2 report was preventing them from addressing themselves to the cases in the scheme, which we felt deserved a greater deal of priority in their attentions. They were a small outfit of, I think, 3 people doing the work, and necessarily just the capacity point prevented them from doing multiple things simultaneously with any sort of speed, and we really wanted them to complete their work on individual cases so we might achieve mediations where they were possible within a reasonable time frame.
You said then that the ship had sailed. So when was the ship in the dock? When did the committee want to prevent the Part 2 report from being finalised?
Well, I honestly don't know, but it does appear to me, on a simple reading of this, that that possibility had been discussed. I think I've seen in earlier documents dating from before my time at the post office that reservations about the Second Sight's performance had been articulated as far back as 2013, and I think they were only retained either at the end of 2012 or early 2013. So very soon after they joined, people were already beginning to wonder whether they'd made the right selection.
We can see from the meeting down G, the committee asked the business to produce an options paper to analyse the most effective way to bring the scheme to a sensible conclusion. Let's go to that options paper, and if we could look at poll 2065, please. I think earlier you were referring to a briefing where Paul Venables challenged you on a reference to impartiality. I think that may be this briefing, which we'll see in a moment. So the issue, a discussion about relative merits of a number of options for breaking through the impasse. The recommendation was that participants to the meeting consider and discuss this paper before coming to a view on the best course of action to take. We can look at the options at the bottom. There's 4. You say, seek to maintain status quo. In circumstances where JFSA do not participate in any meaningful way, second sight's impartiality is a fiction, and all those involved consider that the scheme is not fit for purpose. This option appears to have little to recommend it. Now, is it you referred earlier to Paul Venables challenging you on a matter? Is that this, second sight's impartiality is a fiction?
Yes, I believe so, yeah.
I don't think we need to go there, sir, but for your reference, the email is Paul 201170056. Over the page, other options are mediate all cases or all cases apart from criminal cases. So that's quite a shift from the position well, not a shift because it's an option, I suppose, but that's opening up an option which had previously been rejected in November the year before.
Not quite. One of those is a departure. Mediate all cases would be a complete departure, but mediate all cases apart from criminal cases would have been a refinement on the proposal made by James Arbuthnot and colleagues on the 17th of November. And that refinement was critically important and distinguished it from the proposal made by James Arbuthnot back then.
Well, so I'm going to what was rejected by Post Office, because when we looked at both of the briefing notes prepared by you, there were 2 reasons given for rejecting that proposal. One was rejecting criminal cases, and one was it would involve mediating cases on which Post Office thought there wasn't merit in a mediation.
You're quite right to pick me up on that, and I apologise. I think we saw the mediation of all cases as being responsive to the desire of the JFSA for the opinion of Second Sight to be determinative of the question of what or not we would mediate. And it seemed to us that in the circumstances where we needed to find a way through, that was a concession worth making, even if we didn't necessarily think that all of those cases were meritorious.
There's then that's we should say it says bring an end to the working group. 3 is pay out or pay to litigate, which is essentially offer a sum of money. And 4, end the scheme, mediate cases with merit, defend remaining claims as business as usual. And it says bring an end to the working group while inviting Second Sight to enter into a new contract, brackets ending all others, to complete their review of all cases, anticipated in May 2015, and specifically precluding the production of a Part 2 report. So the ship hadn't sailed, had it? You and the committee were still considering trying to stop Second Sight producing the Part 2 report.
That it appears that was still a consideration. In the event, the combination of options 2 and 4 was the decision arrived at, which did not prevent the production of the Part 2 report, but did involve us rescoping Second Sight's engagement so that they could focus after the production of the Part 2 report exclusively on providing what we assured applicants to the scheme would get as a minimum, which was a reinvestigation of their case and an independent case review report from Second Sight, which they could then use to take whatever action they felt was appropriate, including taking us to court if necessary.
Just want to look at two of those options in a touch more detail. If we turn to page 5, please. This is the mediate all option. And it says all aspects of current scheme maintained, including working group. It appears to be an inconsistency with the earlier bit of the document, but including the working group to oversee scheduling and case throughput, but Post Office accepts the recommendation of Second Sight to mediate as final and mediates all cases. And then it goes on to refer to the variant of not accepting criminal cases. So at this stage, 26th of January 2015, the option you're putting forward for mediating all or mediating non-criminal cases is to keep Second Sight on board. Is that right?
Correct, yeah. Sorry, actually, could you just repeat that?
Yes. So your proposed option for mediating all or mediating non-criminal cases includes keeping Second Sight involved in the scheme.
Yes, it does.
And if we turn to page 9, please. This is the end scheme mediate cases with merit. We see again, Post Office closes the scheme but invites Second Sight to enter into a new arrangement to complete their independent review. A new contract could specifically preclude the production of a Part 2 report. So this is a sort of distinct option from the mediate all. It's where you mediate the case with merit and at the same time make efforts to try to stop a Part 2 report from being produced. Is that a fair summary?
It's one of the options that are in the paper, yes.
Thank you. So looking at the time, I think it's probably time for our second morning break.
Yes, certainly. So 12:25? No, sorry, 12:20.
Yes, thank you, sir.
Thanks.
So can you still see and hear me?
Yes, I can, thank you.
And Mr. Bourke, can you see and hear me? Sorry, Mr. Bourke, could you repeat that?
Sorry, yes, I can.
Yeah, sorry, just to make sure we can hear you. Please, can we go to Poll 20130853? If it's possible just to zoom, that's perfect, thank you. So this is a set of slides. We see it says confidential and legally privileged. We don't need to show it, but your witness statement, paragraph 48, says you assisted in preparing or editing some of these slides for a meeting between Mark Davis, Paula Venables and Alice Perkins. Because it says legally privileged, would you have received any legal advice when drafting these slides?
I imagine so, yes.
Could we look at page 4, please? We can see, so at 4th of February, the advice there is we are therefore disbanding the WG working group, but we agree to mediate all non-criminal cases. We release Second Sight from their work, but offer that if any case, including criminal, wants to use them, they can apply to us for financial support. So, do you recall how that decision was taken, or any discussions that led to that being the proposed course of action?
So I think this would have come after the options paper had been considered, and from memory, this was a briefing taking place between Paula and Alice in advance of a full board meeting. The first two highlighted bullet points should probably be in reverse, in that the ambition was not to disband the working group, but rather, by agreeing to mediate all non-criminal cases, we were effectively making the work of the working group redundant, and that was just the way it was, simply because a decision to mediate had already been taken, and the purpose of the working group was to recommend whether or not that should be the case. In circumstances where we decided to mediate all the cases apart from non-criminal ones, the purpose of the working group, there simply wasn't any need for a working group in those circumstances.
Was there any link between this decision being taken and the appearance of Paula Venables and Angela van den Burgert at the BIS Select Committee?
I don't believe so. I think this was just a continuation of a discussion that had taken place, that had been taking place since late the previous year.
Can we look, please, at poll 21728? At the bottom, we see an email from you to Andrew Parsons saying second site contractual issues. It refers to speaking. Grateful if you could produce a short bit of advice on the manner of implementation and consequences of a future decision to terminate second site's engagement. The advice needs to cover, but should not be limited to, the nature and extent of Post Office Limited's ability to control access to and uses of all and any information it has provided second site, the duration and effectiveness of that control, in particular with regard to the Part 2 report they are preparing, and the legal and practical effects of the 30-day notice period which the letter of engagement provides for. Was this seeking advice on how Post Office Limited may be able to restrain second site from producing a further Part 2 report?
No, it wasn't. I think we were concerned that in circumstances where a decision were taken to terminate this phase of second site's engagement, and bear in mind they were retained to do something else thereafter, we didn't want uncontrolled access to quite a lot of confidential information that had been shared with them in the context of the scheme. In particular, we had shared with them the details of applicants' circumstances, some of which were frankly deeply personal in nature and should not have been reaching a wider audience. As I think we made clear throughout this, the confidentiality of that information was paramount to us.
The email referred to speaking with Andrew Parsons. Can you remember if you spoke to him before the 4th of February slides that we looked at just a moment ago?
I'm sure I would have spoken to him. You mean in terms of the preparation of those slides, or?
Yes, I asked in those slides, did you receive legal advice on it? And I think you said
yes. I'm sure I would have done, or certainly Rod Williams. Bond Dickinson and Rod Williams were working very much side by side in this process.
Can we look at the Bond Dickinson advice that came in response, the note of advice? It's Poll 406364. And the executive summary first points out that second site's engagement can be terminated without restriction on 30 days' notice. It says, on balance, we consider that Post Office can direct second site to do no more work during this notice period. Even if we are wrong, the consequence will only be a damages claim against Post Office Limited by second site for 30 days lost pay. During the notice period, second site are entitled to act on the instructions of the working group. We therefore recommend that Post Office simultaneously disbands the working group on termination of second site, so to prevent the working group giving counter instructions to second site during the notice period. Goes on to say, Post Office could therefore demand the return of confidential information at the same time as giving termination notice. If complied with, this would have the practical effect of stopping any further work by Second Sight. In practice, we would expect Second Sight to resist handing over information. It goes on to talk about publication. Would you accept this advice is effectively giving a roadmap for how to limit what work Second Sight can do?
I don't think that's the primary purpose, but it certainly goes into that sort of territory, yes.
Well, you say it's not the primary purpose. We don't need to have it on the screen, but the points you said the advice should cover was the nature and extent of Pol's ability to control access to and uses of all and any information it's provided to Second Sight, the duration and effectiveness of that control, in particular with regard to the Part 2 report they are preparing, and the legal and practical effects of the 30-day notice period which the letter of engagement provides for. You'd had a discussion with Andrew Parsons. Presumably you discussed what advice you wanted from the note.
Yes, but I think if you're... the concern we had, the overriding concern we had in seeking that advice was the use to which Second Sight might put information which they had been given in confidence, and that was that was really the primary purpose of seeking that advice.
Well, let's go back to your options paper, please. It's Pol 20010265 and page 5, please. Now, this is the more detailed version of the note on the option to mediate all. We saw in I took you previously at page 2 to a summary of it, which referred to bringing an end to the working group. This one says all aspects of the current scheme maintained, including working group to oversee scheduling and case throughput, but Post Office accepts the recommendation of Second Sight. Now, Post Office had adopted the mediate all save for criminal cases, hadn't it? By the time it was seeking advice from Andrew Parsons.
Yes, I think that's right. Yes.
Was the reason that Post Office, or was the reason that the decision was made to close the working group in order to stop Second Sight receiving instructions from them to produce further work?
That was not the predominant, but I don't, to the best of my recollection, that was not a consideration that was certainly in my mind.
You started that answer, it was not the predominant.
Well, I did, and I corrected myself.
So your evidence is you can't recollect if it was a purpose or not?
No, my evidence is that I don't think it was a consideration that was in my mind.
And can you recollect if it was a consideration or it was discussed by other people within Post Office?
I can't, honestly. No, I can't. What I can tell you is that we were aware, or at least I was aware, that having the decision to mediate all cases, the role of the working group was superfluous, and that was given that the working group was not functioning in any event because of JFSA's refusal to discuss any cases that we didn't agree automatically to mediate. That was an acceptable outcome.
Could we look, please, at poll 22512? And if we go to Andrew Parsons' email at the bottom, see it's the 12th of March 2015, and he effectively says it must have been Second Sight that told James Arbuthnot about their termination, and goes on to say we should send a follow-up letter to Second Sight saying that we note that they have breached these obligations despite our warning, referring to the obligation of confidentiality. Your response is to agree and say, having got to the point where after a long time we are sort of in charge, we should make sure they know it. So you were effectively agreeing to threaten litigation against Second Sight in respect of their confidentiality obligations, weren't you?
No. What I was doing is saying that we should send them a letter saying that their breach of their obligations had not gone unnoticed. I don't think anybody ever considered that we would actually take legal proceedings against them, but I think it was important, my email reflects that I felt it was important that they understood that we were not blind to what we felt was taking place.
Well, it says, look at Andrew Parsons' email again, the last paragraph. The letter need not be aggressive, but by pulling them up on them, on each little infringement, we make sure Second Sight do not see these are idle threats. We also avoid any suggestion that we have waived these obligations through doing nothing. This may be important down the line if there's a more serious breach that we do not want to enforce. The idea of enforcing the confidentiality agreements by way of litigation, if necessary, it was very much on your mind, wasn't it?
In the event of a more serious breach, is what Andrew Parsons says. And in circumstances where Second Sight had decided to share with a wider audience details of the individual cases which we were dealing with and which we had guaranteed absolute confidentiality over to the applicants of the scheme, that is potentially a breach that would warrant some sort of enforcement action.
So is your evidence that this was concerned with personal data of the applicants? That's what your concern was?
Yes, I mean, that really was a major consideration and, actually a major hindrance to our being able to make our case, hoisted, if you like, by our own petard on that front, because whilst we were very serious about honouring our obligations of confidentiality, it appeared that some of those applying to the scheme did not feel similarly bound by them, and Second Sight equally did not feel similarly bound by them. So, yes, I think our overriding concern was precisely that.
Well, let's look at poll 21837, please. If you can go down, please, to the bottom email. Thank you for that. Yeah, perfect. Thank you. This is the 8th of June 2015 from you to Second Sight, and it refers to the Panorama documentary by BBC that they were considering to produce. And you say, I know that you are already well aware of your terms of engagement, but I nonetheless take this opportunity to remind you of the restrictions which apply to all contact with the media under Clause 8 of those terms in particular. Now, that's not referring to personal data and protecting personal data of applicants, is it?
Why not?
If you see, It's me to ask the questions. If you want to explain why that doesn't refer to the personal data of the applicants, please say.
Sorry, forgive me. I didn't mean to ask a question of you. I was simply reacting to the fact that, in my mind, that expression is more than capable of encompassing the personal data of the cases in the scheme.
The reality is, Mr. Bourke, you go on to say, I should stress that any breach of this will be strictly enforced by the Post Office. You were seeking to stop Second Sight from discussing matters with the BBC, weren't you?
Well, I was seeking to ensure that they adhered to the terms of the engagement which they'd entered into with Post Office Limited. I don't think that's necessarily the wrong thing to do, or I think this happens daily in a number of companies, that you engage a set of professional advisors, but you don't expect them to go and give interviews to Panorama using confidential information you've shared with them under the terms of that contract. So I don't think there's anything particularly remarkable about this, I confess.
Well, is it the case that what you were doing here, you had a concern that Second Sight were going to give opinions or that would give support to the allegations made by the sub-postmasters?
I think we were concerned that they might both share details of the cases in the scheme, and also, on the basis of what our experience had been of the advice they had provided to us, advance certain propositions for which there was no evidence that would occasion us a great deal of difficulty simply because they'd been put in the public arena.
I want to turn now, please, to the Part 2 report. Please, can we look at Poll 00151715? And we see the subject is Post Office Limited Part 2 response revised. So this was part of work to create Post Office's response to the Part 2 report produced by Second Sight, wasn't it?
I believe so, yes.
If we look at the bottom of the page, please. It's an email from you to Belinda Crowe and others, and you refer to a Word document with some wording, which they say tweaked wording attached. We go up to Roderick Williams's next email. It says, good distinction, but I think it should reflect the actual offence. And we're talking here about false accounting. Would you be happy with this? Says it is important to understand that sub-postmasters are not prosecuted by Post Office for incurring losses in branch. Prosecutions for false accounting occur where a person dishonestly falsifies branch accounts with a view to gain for himself or another, or with intent to cause loss to another. In your responses above, I would personally end the sentence after accounts. So effectively what you're saying is remove the words with a view to gain for himself or another, or with intent to cause loss to another. Correct?
Yes.
And the reason you give is that you would not want to encourage a subjective debate about whether or not applicants intended to gain or cause us loss. I can just see someone saying, I was in such a muddle, I didn't know what else to do, but I didn't mean to. Were you aware at the time that the words with a view to gain for himself or another, or with intent to cause loss to another, was wording lifted from Section 17 of the Theft Act 1968 concerning false accounting?
I don't believe so.
the fact that Roderick Williams said, but I think this should reflect the actual offence, did that not tip you onto it?
Well, I don't know where he'd drawn that from, but yes, I accept that it was a statement that had been drawn from some source. I didn't know whether it was the Theft Act 67 or anywhere else, but yes.
Is what you're saying here that you wanted to avoid applicants arguing that they didn't have a view to make a gain for themselves or another, or that they didn't have any intention to cause loss?
So I think I was advancing a view on the basis that in the cases we had in the scheme, the cases we'd seen, there were lots and lots of cases that involved false accounting, not just on one occasion, but on multiple occasions, stretching in some cases to multiple years. And I think at that point, it would be difficult to make the argument that it was the product of confusion or being in a muddle. Now, I've clearly stated the law wrong, and for that, I'm happy to apologise. It was a suggestion. I've asked whether it makes sense, and I don't know whether it was taken up.
Well, Mr. Bourke, what you're saying here is let's not encourage anyone to grapple with the issue of dishonesty, really, isn't it?
Well, I didn't see it like that at the time, no.
How did you see it?
Well, as I've tried to explain, many of the cases we were looking at involved periods of false accounting stretching in some cases to years, and I think it's difficult in those circumstances to attribute that to being muddled or doing it by mistake. So I think in those circumstances, I think the case is more arguable about whether or not that constitutes intent to cause loss to another. But it's clearly wrong. So I didn't know if it was right. Hence my question: does that make sense? And as I say, it was a suggestion rather than me sort of saying this is what we're going to do.
Can we look, please, at poll 201294447? This is on the 9th of March 2015 from Andrew Parsons, and you're copied. It says, on the remote access point mentioned below, Simon is referring to this extract in the scheme report. It says the Deloitte report cited by Simon below describes the balancing transaction process. Now, when you received this, presumably you would have looked down to the email below for context and to understand what Mr. Parsons was talking about.
I'm not sure. I mean, the email was not addressed to me, as you can see. So I may have done, I may not have done, I don't know.
But remote access at this point was quite an important issue, wasn't it?
Yes.
And so, with that in mind, do you think it's likely that you would have looked down to see the substantive email to which Mr. Parsons is referring?
It's possible, but I can't tell you for sure.
If you could turn to page 2, please, to look at the email. It's from Martin Smith, and it says, may I also take this opportunity to mention a point which Simon Clark has raised. He has noted that the end of term report contains the following proposition. It says there's no functionality in Horizon for the Post Office or Fujitsu to edit, manipulate or remove transaction data once it's been recorded in a branch's accounts. The Post Office can only post additional correcting transactions to a branch's accounts, but only in a way that are visible to postmasters, e.g. transaction corrections, transaction acknowledgements. It is also possible for Fujitsu to view branch data in order to provide support and conduct maintenance, but this does not allow access to any functionality that could be used to edit recorded transaction data. And he goes on to say he has also commented that the Deloitte report includes a comment to the effect that they have observed in their desktop audit a method of posting balancing transactions which allows for posting of additional transactions centrally without the requirement for these transactions to be accepted by SPMRs. Accordingly, goes on to say, accordingly, we are concerned that should the Deloitte report subsequently be disclosed, people may be able to compare both documents and argue that they are inconsistent. Were you then aware of the Deloitte report at this time in March 2015?
No, I wasn't. Not as the Deloitte report. And I think this refers to Project Zebra, if I'm not mistaken.
Yes.
I was aware of balancing transactions. I didn't know that the balancing transactions knowledge came from something called Project Zebra and the desktop exercise performed by Deloitte prior to my arrival. And I wasn't aware of the fake basket hypothesis as well.
So if you say, no, I wasn't, is your evidence that you didn't read this email from Martin Smith?
I don't think I would have read it. No, I think this email, if you just scroll up to the people in between, is an email between Martin Smith and Roderick Williams, and then you can go up again. It's a conversation between Roderick and then if you look, the email to which I'm copied into, and which I would have paid the most attention to, he goes on to say, if we wanted to make the extract complete, we would need to add something like blah blah blah, and then he says about balancing transactions, about which I knew. I don't know whether he then goes on to say anything about the fake basket hypothesis. In fact, he doesn't. So,
well, Mr. Bourke, it says there above where it's highlighted the Deloitte report cited by Simon below. Presumably, you would have read that.
No, I don't think I would have done.
So, your evidence is, I think, that this email that says Roderick and everyone else by copy, which you're copied into, you're saying you didn't read it.
No, I'm saying I read the bit that was
Okay, so if you read it, you would have read it says the Deloitte report cited by Simon below.
I agree I would have read those words. That doesn't mean I read the documents cited below. I took what I needed for my purposes from this email that was addressed by Andrew Parsons to other people, and I was copied into it.
Is your evidence at this stage, having read this email, that you were or were not aware of a report by Deloitte that covered balancing transactions?
I was aware of the balancing transactions element, but not the fake basket element. And I agree with you, had I read all the way through to the end and looked at Martin Smith's correspondence
Sorry, Mr. Bourke, that's a different question. My question is, when at this point in time, 9th of March 2015, I'm trying to clarify if your evidence is that you knew that there was a Deloitte report that covered balancing transactions.
I'm not sure if I knew there was a Deloitte report until this email, but I knew about the balancing transaction process.
Right, so you received this email and you know there's a Deloitte report.
But I know there's a balancing transaction process. I didn't know where it had emanated from.
I'll ask that again. 9th of March 2015, are you accepting that you knew that there was a Deloitte report that described balancing transactions?
Having read this email, yes.
So I wonder that might be an appropriate place to stop for lunch. I would ask we could start again 5 minutes early at 5 to 2.
Yeah, but let me just ask Mr. Bourke this question. The balancing, just so that I'm entirely clear, that's all I'm doing it for. You acknowledged this morning that you were aware of what I'll call the James Davison email, the
Yes.
Fujitsu email. And you obviously would have been by this stage, yeah?
So I was
The
aware-
balancing transaction that Deloitte refers to, is that the same as the revelation in the Davison email?
I believe it is, yes.
Yeah, well, that's what I thought. Does that throw any light upon how you would have viewed these emails? In other words, were you being told something at the back of your mind you already knew, or was this new information?
Well, I mean, that was the point I was trying to make, and obviously unsuccessfully, that I was aware of the facility of balancing transactions, but I was not aware of it as having been recorded in a Deloitte report.
Right, okay, I understand. Right, do you want an extra 3 minutes, Mr. Stevens, in view of that intervention?
No, sir. If we can come back at 1:55, I'd be grateful.
Fine, thank you.
Thank you.